Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, January 15th, 2020. The time is about 9:32. And with us today are Commissioners Emily Lindley and Bobby Janeka, and our General Counsel, Mary Smith. I'm John Neerman, and I'll ask Ms. Smith to please call the first item.
Item number 1 is the application by the City of Leander for a major amendment of Texas Pollutant Discharge Elimination System Permit Number WQ 0012644001 to authorize an increase in the discharge of treated domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask questions.
So, Commissioners, the threshold question for granting a contested case hearing is whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit, both in timely comments and a hearing request, are entitled to a hearing. In this case, I agree with both the Executive Director and Public Interest Counsel that the requesters are not entitled to a contested case hearing. Mr. Berger and Mr. Rosinski have failed to say how they would be personally affected by the permit, while Mr. Burleson and Mr. Salinas reside too far from the facility to be able to point to an interest that's different from one common to the general public. So I welcome your thoughts. And also a motion.
I'm in agreement.
Likewise.
I have a motion. Okay. I move that we deny all hearing requests and that we grant the major amendment to the City of Leander for TPDS permit number WQ 0012644001 as recommended in the draft permit prepared by the Executive Director and adopt the Executive Director's response to comments.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Item number 2 is consideration of the material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed during the previous quarter.
Good morning. We moved through that first one so quickly, we didn't give you a running start. And let's make sure your mic is on it.
Thank you.
There we go.
Good morning, Mr. Chairman, Commissioner Lindley, Commissioner Janeka, General Counsel, and Public Interest Counsel. For the record, my name is Robert Apolinario, Contract Specialist for the Financial Administration Division. I am representing the Executive Director. This item contains the material changes made to contracts and purchases for goods and services between June 1st, 2019 through August 31st, 2019. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more. In accordance with Section 2155.088 of the Government Code, the Executive Director presents these items for your consideration. I'm available to answer any questions you may have.
Thank you. Colleagues, any questions?
No questions.
Seeing none, Mr. McWhirter.
OPIC recommends approval of the resolution acknowledging material changes to contracts for goods and services as presented by the Executive Director.
Any questions for OPIC?
None.
Thanks.
Thank you. I agree with that and think it's appropriate to proceed.
I agree.
I would move that we approve issuance of the Executive Director's proposed resolution that acknowledges the material changes to contracts for goods and services in accordance with Texas Government Code 2155.088 for the period of June 1st, 2019 to August 31st, 2019, as described in the TCQ Interoffice Memorandum to the Commissioners and Executive Director dated January 15th, 2020 in docket number 2019-1636-MIS.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
That takes us to the enforcement docket, items 3 through 49. Item 36 has been remanded at the request of the executive director. On item number 8, we have several individuals, or we have an individual who signed in but indicated that they don't wish to speak. And on items 6, 34, and 45, we have interested persons who have asked to address the commission. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I'm the Agenda Coordinator for the Litigation Division. With me today are Charmaine Backens, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before you are items 3 through 35 and 37 through 49. The total assessed administrative penalties are $807,126, with $134,531 deferred, $282,133 applied towards supplemental environmental projects, and $378,462 to the general revenue. The Executive Director requests a continuance for item number 29, Isleta ISD. The Supplemental Environmental Projects Third-Party Administrator, Trans-Pecos Water and Land Trust, is no longer accepting contributions. TCEQ will coordinate with Isleta ISD in preparing another supplemental environmental project and present at a later commission date. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none at this point. Colleagues, any questions?
Right now.
No questions.
Okay, we have several interested parties who are signed in, and so we're going to limit comments to 3 minutes apiece. And first up, we have Ms. Din on item 6. Good morning. Let's make sure the light is on your microphone so we can hear you, and then just state your name and your affiliation for the record.
Yes, sir. Thank you. My microphone is on. My name is Amy Din with Lone Star Legal Aid, representing Port Arthur Community Action Network. Port Arthur Community Action Network is a community organization that works on behalf of low-income and minority residents in Port Arthur, Texas. And before I begin, I would just like to say thank you to the chairman, commissioners, executive director, OPIC, and staff for being here and allowing us the opportunity to speak. The commissioners have an agreed order before you that will assess penalties of $15,000 to German Pellets Texas LLC regarding air quality violations that created nuisance conditions in Port Arthur, Texas from April 15th to July 25th, 2017. While a positive step by the agency, the order contains 2 critical errors and therefore is a misapplication of the agency's own penalty policy. And for these reasons, the matter needs to be remanded to the executive director. The violation in question is more accurately described as a continuing violation as opposed to 4 single events. But what's at most concern for Port Arthur Community Action Network and the residents of Port Arthur are the following 2 issues. First, the violation is calculated as an actual moderate violation, but it should be calculated as an actual major violation in accordance with the penalty policy. Second, the violation is calculated as 4 separate events as opposed to a continuing violation over which the nuisance events occurred at least the 22 days noted by the TCEQ staff. And we would say it was an ongoing violation based on the air emissions report database incident 256416 that attributed the violation from April 16th to July 21st. To the first issue, which is the assessment of harm. The only difference between an actual major violation and an actual moderate violation is whether or not the levels are protective of human health and the environmental receptors have been exceeded. The TCEQ agrees in this case that there were significant amounts of pollutants released. In this case, the fire at the facility caused health issues to hundreds of residents, and Mr. Beard of the Port Arthur Community Action Network is going to speak to those specific issues. The database incident report stated that the PM10 wood dust being emitted during the event was 60%, which is more than 1,200% of the 5% opacity limit allowed under its permit. And there are a number of violations that were and conditions that were documented in our comments that were submitted back in December 2018, which talk about the impacts on the community. It triggered not only a lawsuit by the residents, over 467 of them, but also by the city that stated the nuisance conditions were dangerous and a threat to the safety of Port Arthur residents. And as to the second issue on the number of violation events, the penalty calculation is based on 4 events, and the penalty policy is really clear. When you have a continuing event as opposed to a discrete event, like a failure to submit a report or something, you have it is a continuing event that has to be assessed. So when you change the base penalty to
That's time.
I'm sorry.
And I'll allow you just a
Thank you.
moment to wrap up.
Thank you, sir. I appreciate it. The base penalty should be increased to 7,500 for a major harm, and then it should be assessed at a daily penalty based on the continuing violation. As such, that $15,000 penalty needs to be revised and remanded to the executive director or referred to the state office administrative hearings for 2 reasons. The base penalty should be increased to the 7,500 for a major harm, and then whether that daily penalty should be assessed for the continuing violation event.
Thank you, Ms. Den. I appreciate your comments, appreciate the comments that were submitted on this. Colleagues, any questions for Ms. Den?
None. Thank you.
Thank you.
Thank you.
And Mr. Beard, we'll hear from you now. Morning, sir.
Good morning. How are you all doing?
Doing well, thank you.
First of all, let me say again, good morning to the chairman, fellow commissioners, general counsel, chief clerk, and those of you present. I'm here representing voices that cannot be heard in the Port Arthur community, the west side of Port Arthur, the historic west side of Port Arthur. We have a number of people who are elderly, senior citizens, disabled persons, and young families, mothers, single mothers with children. I ask that you look at those pictures that I gave to you, and Ms. Den is quite correct. This was not just 4 isolated events. This was a continuous ongoing event in 2017 that began on Easter weekend, Easter Saturday, and it continued until the 25th of July. The smoke you see, can you imagine if you're like having a barbecue or you burn something in the kitchen and the house is full of smoke? Imagine outside being that smoky room, 24 hours a day, 7 days a week for 102 straight days. You having to breathe that fumes and the noxious odors that come from that facility because of something they did. So I'm here to speak to that and encourage you to follow what Mrs. Den is saying, but also to take further action with that, because we as citizens don't have a lot of protection in that area because a gag order was placed on the city as well as German pellets, and they can't even tell us what they've done to make us any safer or better. But I'm here to speak for Miss Geraldine Carter. She can't be here because she's deceased. But Miss Carter died 3 days before her daughter was to come and take her to the doctor. And she complained to her daughter about the fact of having trouble breathing. I'm here to speak also for a couple married over 50 years, Mr. and Mrs. Dunbar. And Mr. and Mrs. Dunbar's daughter came from Houston, Texas, and brought them to stay with her for several weeks. But you know, like some of us are going to be when we get older, we want to stay around things that are familiar and close to home. So they wanted to come back, and she obliged them. I'm also speaking for Miss Alcina Hardy. Miss Hardy's grandchildren were so sick that they could barely breathe at night. They had to have breathing treatments. And I'm also speaking for Miss Annette Mitchell, who is on a breathing machine as we speak. These people were all affected by this. And by giving them a simple slap on the wrist of that meager and small fine, you don't send a message to that company and others that you are going to be diligent about doing your job to protect us and protect communities of color. So I ask you to consider what Ms. Den has said, to look at those pictures. I'm sorry I couldn't let the rest of you see it. It would have been something for you to really understand our condition. But once again, thank you very much for this opportunity to speak, and please keep us in mind and also keep us in your prayers. Thank you.
Thank you, Mr. Beard. Any questions for Mr. Beard?
Thank you.
We just got these in our hands. They were attached to your comments, so they are part of the record on this item. So I'm going to pause for a moment just to take a look at the photographs, and then we'll hear from our next commenter. Is it Mr. Boldazar? Thank you, Mr. Beard. Sir, did I pronounce that correctly?
You did, Mr. Chairman, thank you.
Thank you.
C. Davin Boldasar, I'm counsel for German Pellets Texas LLC. Thank you for giving me the opportunity this morning. Very briefly, there was a response filed in December 2018, which Ms. Den and Mr. Beard referenced. We filed a response on January 29th, 2019. I'm not going to belabor those papers; those were in the record before the commission. Just to give a little bit of context to this event, this was an accident. This was not some kind of normal business operation. There was a smoldering burn that was experienced at the facility. The company exercised very strenuous efforts to put that out, which took many months. That was done with coordination and with the supervision of the Port Arthur Fire Department, who was on the scene directing all efforts. It was also done in conjunction with the TCEQ, who was involved and was part of the air monitoring that was done. There was a hazard analysis plan that was done with the City of Port Arthur Fire Marshal. That hazard analysis plan was a complete analysis of the entire facility for fire risks, and resulted in an agreement with the City of Port Arthur Fire Marshal on a number of actions that were taken to prevent a recurrence of this from happening again. So the company, undertook strenuous efforts to address this situation. Certainly regrets, any impact on the community, but did everything within its power to address it. And I should just say also very briefly, the company is in Chapter 11 bankruptcy, has been for some time. This matter, this $15,000 assessment, has already been paid. The way it was structured with the agreed order was $12,000 was to be paid, $3,000 was deferred. Because of the nature of our Chapter 11 bankruptcy proceedings, a plan has already been confirmed, and this matter has already been resolved as far as the bankruptcy court is resolved. So the assessment has been paid. I believe, just for the record, I don't have it in front of me, but that was earlier this year in terms of the timing on that, and that was done in conjunction with with the Attorney General's office, counsel for TCEQ. And so, unless there are any other questions, again, we certainly regret the incident in terms of any impact on the community, but the company has undertaken very strenuous efforts and has done everything as possible to address the incident.
Mr. Boldazar, can you address what the root cause or causes were, and then also give me a flavor of what those efforts are to prevent recurrence?
So the actual cause has never actually been determined. So what happened is...
Was there an inquiry into
there
that?
absolutely was, and there were experts involved, and there's actually some litigation ongoing in which there may be further experts looking into the actual cause.
And the experts are third-party consultants?
Correct. So the company engaged the firm Jensen Hughes, which is a fire expert. Primarily, Jensen Hughes formulated the hazard analysis plan, which was basically to make sure that nothing like this would recur again. And so that plan addressed fire risks throughout the facility, even parts of the facility that had nothing to do with the actual incident. And so that expert, looked into the cause as well. This incident took place inside one of the silos. Let me just take a step back, if I may, if you'll give me a minute. This is a facility that stores wood pellets and stores in 5 large silos. There's also a conveyor system that moves the pellets out of the silos to a port facility where they're loaded onto vessels. Okay, this burn started in one of the silos. It started very quickly. There was a temperature monitoring system and a fire suppression system at the facility. This started very, very quickly without any warning at all. And very quickly became a fairly significant event that the fire department came out for, et cetera. Other than the fact that it did start in one of the silos, the actual what actually went wrong has never actually been conclusively determined. We did have a third-party expert look, very, very thoroughly at it. As you can imagine, with there being some litigation with some of the other parties, third parties have also engaged experts, and down the road there may be a more precise cause that is determined. But what I will say is this.
And if I can interrupt you for just a moment, what I'm thinking of is how do you know that you have the right preventative measures in place if you don't understand the root cause?
Certainly. And the answer, and that was just about what I was about to say, the answer to that is that the firm of Jensen Hughes, in conjunction with the City of Port Arthur Fire Marshal, did a complete analysis of all fire risks at the facility. That resulted in this thing called the Hazard Analysis Plan that had a number of different action items to address any possible risks at the facility, to include what may have actually caused this incident as what could cause any other incident at the facility. That process took approximately a year, so it took quite a while. And it involved a number of agreed steps with the City of Port Arthur Fire Marshal that were taken in the rebuilding of the facility. And those steps have all been taken, and the facility is operating today. Now,
So you've implemented all of the recommendations that came from.
correct. There's a little bit of complexity there because there were actually it was a phased approach where there were 4 phases of work to be done. One of the phases, the company actually had a year to put things in place, and in the middle of that time frame, and this is the last thing I was going to get to, my client, German Pellets Texas LLC, actually sold the facility as part of the bankruptcy, and so German Pellets Texas LLC no longer owns the facility. There's a third party that owns them and is responsible for putting some of those final last touches in place. However, all of the steps that were required to reopen the facility were taken. The fire marshal inspected all of those systems and steps and approved all of that.
Okay, and so the purchaser is relying on your client to wind up any open issue with this enforcement action?
Correct.
Okay, I understand. I think that might exhaust my questions for the moment. Colleagues, do you have any questions?
One follow-up to the question you asked was there any further analysis done to the appearance of fire or possible fire in Silo 3 as opposed to Silo 2? I imagine that might have provided a different field to go back and study. Was there any additional information gleaned from that? Possibly it was a different cause entirely?
No, it was not a different. So the answer is yes. There was a lot of analysis about everything that had to do with inside the silos. I believe what you may be referring to is that during this incident, silo number 2, obviously there were some high temperatures in silo number 2.
Mm-hmm.
The silos are adjacent to each other, and so at one point there was a hot spot, what was called a hot spot in silo number 3. There were tremendous efforts made to keep that from turning into a fire, including the injection of liquid nitrogen on a continuous basis for months and months. If you went to the site, you would see just kind of truck after truck lining up and injecting nitrogen into the silos. So essentially that cause was basically, there wasn't some independent cause, it was just that they're right next to each other and the heat spread from one silo to the next.
That helps.
I think that exhausts our questions for you. Thank you for being here.
I'm sorry, can I just, I've just remembered one other detail.
Go ahead.
That, what also you may be referring to, at one point, and we haven't gotten into this, but silo number 2 actually collapsed in the midst of this incident. And so I believe what actually happened is that silo number 2 had collapsed, so there were basically a mountain of pellets sort of right next to silo number 3 that still had some temperature in it. So that may be that was likely the cause of that hotspot.
Thank you.
Thank you.
Thank you.
Before we move on to the next item, I do have a follow-up question and thank you, sir, for the executive director. Actually, 2 questions. The first responding to Ms. Din's assertions about the legal vulnerability of the penalty assessment here, if you could comment on that. And then the second one is, to the extent you can comment on the effect of the bankruptcy, if we were to pull this back and remand it for a different penalty calculation, would it make a difference, and what would that difference look like in the bankruptcy process? I gave you some difficult questions.
Okay. I'm going to take the first question.
That's the easy one.
Yes, it is. The second question, I'm going to have to call in reinforcements here. The penalty was calculated, again, as was already mentioned, as an actual moderate, which meant that there were significant amounts of pollutants which did not exceed protective levels. In the investigation report, there was not documentation of health effects. It does mention that some of the complaints included some health effects, but we did not have documentation such as medical records or anything specific about that. The smoke and odors associated with the smoke itself were evaluated in accordance with the protocol that our investigators use for this, which is commonly called FIDO, but is frequency, intensity, odor, duration, and offensiveness. And in using this particular protocol, the smoke and burning wood smells were characterized as moderate, unpleasant odors, and classified accordingly in the protocol or the procedures that we have for that. So when we do that, it's if the odor is not complete, really bad or really offensive, according to the guidance that we have, then it may take several instances or observances for days or for periods of time over several days to constitute the documentation of a nuisance. In this case, even though there were 22 days in which observations were made or documentation of odors was made that contributed to the 4 nuisance violations that were documented, it was several days that led up to it. So the April 28th nuisance had many days associated with it prior to it before the nuisance was called. Again, on May 12th, there were 4 days prior to May 12th, or including May 12th, that contributed to that. Same for May 25th, the same for June 4th. And so the way that we did it, and I can appreciate the observation that it was continuing. If we had called it just a continuing violation from the beginning to the end, we had called it an actual moderate, we would have ended up with monthly events, with either 3 or 4 monthly events, depending on when it started and when it ended. But that's an explanation of how we got to where we got.
I appreciate that. Colleagues, any questions on that topic before we move on to the bankruptcy question?
I have a couple.
Yes.
Specific to that FIDO determination, what was the factor, the material difference in those 18 observed but not determined to be nuisance days versus those 4?
There were various days that were better or worse. I don't have that information right in front of me. Why that first one, that April 28th, took so many days to document a nuisance, but I can get that information.
I appreciate that. And I note that the observation was made in that inspection report, and then in the description of the item in our backup, that it was observed for a duration of 2 hours on several of those days, or 22 of those days. I see that the FIDO chart does give different time durations to make different determinations. Was 2 hours the extent of that nuisance, or that observation, and it lessened outside of those 2 hours, or was that more a limitation on just staff's ability to be there for that duration of time, which I understand is a very that's an imposition on limited agency resources. However, I'm curious, was there any distinction there?
Why was it 2 hours and not more
Right.
hours? I don't have an answer to that question.
Okay. And finally, you mentioned that there were several days leading up to it, and just in the interest of consistency, I think that there was I seem to recall similar matters coming before us just in the time that I've been here, where those days leading up to a nuisance condition were included in the agreed order as different. The count appeared to be different, and that's primarily where my interest is. I'm wanting to ensure that I'm able to understand and explain the consistency in our approach to actions. Has there been any, and there may be a difference in the time that was screened and moved forward in the enforcement process. Can you speak to that at all?
We have been adjusting our approach to nuisance odor violations. I think that what you see here represents in a way that we used to do it. We have been trying to make changes to that approach to make the penalties more reflective of the violation. And in what you would see on many cases, especially the ones we're currently doing and the ones that were mostly done after this, is that we would do separate events for each day that an odor was documented that contributed to the nuisance. And so if it was done that way, there would be 22 events rather than 4.
Answers my question perfectly. Thank you.
Thank you. Bankruptcy.
Good morning, Chairman, Commissioners, and General Counsel, and Office of Public Interest Counsel. I'm Charmaine Backens with the Litigation Division. Behind me is seated Barbara Watson with our bankruptcy program.
Next to you now.
Next to me. Very good. I can tee this up a little bit, and if you have more specific questions, I'll defer to my colleague here.
Great,
to my
thank you.
So we do have a bankruptcy court order that had a stipulation attached to it that references the docket number that is before you today. It assessed a $12,000 penalty, which has been paid. There were not corrective actions laid out in this particular stipulation, but the order acknowledges that any necessary corrective actions have been completed, and that the violations were, and the matter set forth in the petition, were withdrawn. And that's the information that I have on the bankruptcy part of it. Do you have anything to add?
So imagine if we were to remand it and with instructions to reevaluate the violations against kind of our current approach on the penalty policy, and we came up presumably with a larger number. What are the mechanics of that with the ongoing bankruptcy?
So this is a case that is currently with our Office of the Attorney General. They represent us in this bankruptcy. I can't speak in detail to that. I can say, in general, deadlines in bankruptcy move very quickly. Yeah. This stipulation has been in place for some time. The claims deadline is passed. So I don't know whether or not there would be an opportunity for us to begin again, but we could certainly explore it with our Office of the Attorney General representatives.
Okay, I don't think I have any other question. I mean, I have questions, but they feel like they're unanswerable, perhaps short of speaking with the Attorney Generals, and I get that. I appreciate that. Colleagues, any questions? Okay, I think at least for the moment that that satisfies my questions for staff on item 6, and I think so we don't have too disjointed of a conversation. We'll invite Public Interest Counsel to offer any observations or comments that you want to on item 6.
I appreciate the questions that you asked, and I think they hit on the concerns that I have, especially the practical matter about the effect of bankruptcy. I have trouble with the number of violations that were cited, and for that reason, I can't wholeheartedly support the penalty calculation as proposed in the order, but I understand if, because of practical concerns and the fact that it was calculated, the penalty was calculated consistent with the practice at the time, I understand why, if there's a need for all those reasons, to move forward, but I would withhold my support for now.
Thank you. Colleagues, any questions for Mr. McWhirter on item 6?
No, thank you.
Okay, let's move on from item 6 for now. We have, I think, the manager of Dairyway Food Mart signed in. And, sir, I'm sorry, I can't quite make out your last name. So if you want to state your name and affiliation for the record, and you have 3 minutes.
My name is Amir Ali Charania, and I'm the operator for the store located at 5235 on South Davis Boulevard at Dairyway. There was a notice that was issued to us in 2019, and I had a death in the family. My brother had passed away. That 1 year was a severe turmoil in the family, and I wasn't taking care of my businesses. He was my best buddy. Unfortunately, all the businesses had so many problems last 1 year, but now the family has to live. I have decided to take care of all those problems and slowly trying to solve them. I've got the test results, and I have produced to the lady earlier today, and I've got my insurances and all the paperwork that has been maintained. I already submitted it. Today, I'm here not to argue, not to request for anything, but have some mercy on us to lower our penalty and give us at least a 1 or 2 quarters so that we can get back everything in line and submit all the documents as required by TCEQ. That's all my request is.
All right, thank you, sir. Colleagues, any questions at this point?
No,
All right.
thank you.
Thank you.
Thank you for
Appreciate
your comment.
Thank you.
I'm going to invite staff to offer any comments that you may have on this, if any.
Thank you, Chairman. Charmaine Backens with Litigation Division. The backup reflects that the EDPRP was filed on January 8th and properly served on the respondent. He also received the proper notice of the shutdown order, and he did not file an answer, failed to file an answer, and the pre-investigation, the pre-agenda investigation was conducted on the January 7th, and it showed that he was non-compliant at that time. So we would recommend that we move forward with the order.
Colleagues, any questions? Mr. McWhorter?
I agree with the executive director's position on this.
Thank you. And sir, let me say that I'm very sorry for your loss. We'll discuss this item, I think, in just a moment when we wrap up here, but we've got more commenters, so I appreciate your presentation. Moving on to item 45, is it Ms. Grubert?
Good morning.
Good morning.
My name is Frances Grubert, and I'm the office manager for the Victoria County Water Control and Improvement District Number 2 in Placido, Texas. And we're not here disputing anything. We do acknowledge, and we have paid the fines and everything, but the Board of Directors has asked me just to come talk to y'all for a minute. We have a new Board of Directors who are trying to correct things. They hired a new operator when they came on board, but unfortunately, due to unsatisfactory job performance, he has been replaced recently. And our new operator is working very diligently to catch up maintenance, catch up all the paperwork. And so basically, I just want y'all to know that we are trying very hard, and we do want to get current on everything, and that y'all know that we do care. And we are trying to represent our community well and keep them healthy.
Thank you, ma'am.
Okay.
I appreciate that and really appreciate you being here today. Colleagues, any questions or comments?
I agree, and if you need something from us, clarification or just understanding, folks in our Office of Water and our Office of Compliance Enforcement are great to work
Y'all will be hearing from
with.
me because this is a totally different field than I used to be in, and so our operator and I will now be working together, going through these old problems and calling y'all to say, okay, what can we do? What do we need to do?
That'd be great.
We do have a small business and local government assistance program that can do some compliance counseling. They're top notch. We also have a special team that actually focuses on technical expertise on wastewater systems. We call it the TOPS team. They're fantastic. So let us know how we can help. We're certainly sensitive to the problem or the challenge, I should say, of finding qualified operators and keeping qualified operators.
And we're a very small district, and there's been years of neglect, so we're trying to overcome a lot. But
and of course, making sure our drinking water is safe is of utmost
we have a lot
important.
of elderly clients that we want to keep healthy.
Yeah. Well, thank you for making the trip.
Thank
I
you.
appreciate it. All right. I think that might be the end of the comments. So, colleagues, I guess let's take them in order. Item 6, and I walked in here this morning concerned about this item, but without a particular direction that I had decided on, and I thought I would poll you to see if you had any thoughts on how we might proceed.
I was approaching the item, I think, in the same frame of mind. My questions have been answered to my satisfaction where I think it's, unfortunately, there's no overwhelmingly, obviously, satisfactory alternative path forward. I think that in keeping with consistency in our practice over time, it makes sense to me now how we arrived at this point. I'm comfortable moving forward if the both of you are, or either.
Yeah, you just need one of us.
Right. It's new dynamic.
I'm comfortable moving forward as well. So I would, propose that we adopt what the ED has proposed today and what's in front of us.
I'm also comfortable with that. Let me do register, though, that I'm glad that we've adjusted our approach to these types of events, because I don't think where we landed on here is really where we want to be. I do think that this order is legally defensible. I just don't think it's the best place for us to be on the policy, so I'm glad that we've updated our approach. And let me also express some disappointment that the new owner isn't here to let us know how they're going to operate this facility going forward. I understand that the entity that's now in bankruptcy is responsible for resolving this, but what's going to be important for the community is to have a responsible neighbor going forward. And so I would encourage the new owner to do, well, first of all, make sure that their ducks are in a row in terms of how they operate that facility, how they address the past event, how they implement measures to prevent future events, and very importantly, reach out to their neighbors and work with their neighbors to explain to their community how they're making it right and how they're not going to repeat the harm that was visited earlier, and it's the subject of this violation. I know, sir, that's not your client, but maybe you can encourage them to listen to those admonitions. And so even though the penalty amount in this order perhaps isn't what it should be and isn't what it would be if it came in the door new, I agree with my colleagues that at this point, given the difficulty of gathering any more in bankruptcy, that we ought to just move forward with the order as is. That I think takes us to item 34. And colleagues, I'll open it up to gather your thoughts on that as well. Dairy Way Food Mart default shutdown order.
It's tough. It is. It's hard when, you hear those kind of comments and understand that people have lives, and sometimes there's things that happen in your life that affect your business operations. However, I think we do have to move forward with what's proposed today by the executive director. I think everything in the record leads me to that conclusion, and so I'm comfortable with doing that.
I agree. Commissioner Janeka, do you want to offer any comments on that?
I'm landing in exactly the same place. It's very, first and foremost, I think the importance is to have consistency in our approach to all the stakeholders we deal with. And again, my sympathies, I'm sorry for your loss. I hope that we may offer what flexibility we can within the appropriate processes we have, payment plans, things like that. And again, I think there's a lot of resources to the agency that will be available to assist if there's any difficulties in trying to get back into compliance, but I'm comfortable moving forward right now.
Thank you. So I think, Mr. McWhorter, we've heard from you on the individual items. We haven't heard from you on the totality of the enforcement docket, so I'd invite you to offer your comments now.
Yeah, my office reviewed all of the other items discussed, and we agree with the executive director and recommend approval of those orders.
Thank you. Colleagues, any further questions or comments?
None.
No. I can do a motion if you're ready.
And I think there was a continuance on item
Yes,
29. You're
29.
sensitive to that? Okay.
Yes, I would include that in my motion. I would move that we continue item 29 until a future agenda, and that we adopt items 3 through 28, 30 through 35, and 37 through 49 as recommended today by the executive director.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 50 is the consideration of the publication and hearing on proposed new amended and repealed sections of 30 Texas Administrative Code, Chapter 344 regarding landscape irrigation. The executive director's staff is here to present this item. We have one person signed in who does not wish to address the commission. Their presence will be noted for the record.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Al Fuentes of the Program Support and Environmental Assistance Division. With me is Ms. Alicia Ramirez with the Environmental Law Division and Ms. Christy Mills-Jarak with the Program Support and Environmental Assistance Division. The proposed rulemaking would incorporate some of the changes requested in the 2 rule petitions approved by the Commission on October 4, 2017, as well as amend existing sections, repeal Section 344.32, and add Section 344.66 in order to be better aligned with state statute and other regulations. These proposed revisions would strengthen the rules to increase the protection of public health and increase water conservation. A public hearing will be offered on this proposal here at the TCEQ campus on February 27, 2020. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 344 Landscape Irrigation. Staff also respectfully requests permission to make non-substantive revisions to comply with the Texas Register requirements. Thank you. We are available to answer any questions.
Colleagues, any questions?
No questions, thank you.
None, thanks.
Mr. McWhorter.
OPIC recommends approval for publication of and hearing on the proposed rulemaking for Chapter 344, so the Commission may receive and consider public comment, and we appreciate the efforts and input of the stakeholders who've participated so far.
I agree. I want to thank the Irrigation Advisory Council for presenting this issue. I think it's the amendments are sensible, and we'll entertain a motion.
I would move that we approve the publication of and hearing on proposed new, amended, and repealed sections of 30 Texas Administrative Code, Chapter 344, as recommended by the Executive Director.
Second?
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you.
Item 51 is consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 114, to implement House Bills 1346 and 1627. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Amancio Gutierrez with the Air Grants Division. With me is Sierra Redding with the Environmental Law Division. The proposed rulemaking would amend Chapter 114, Control of Air Pollution from Motor Vehicles, Mobile Source Incentive Programs, Diesel Emission Reduction Incentive Program for on-road and non-road vehicles, Subchapter 114.622 and Subchapter 114.629, as amended by House Bills 1346 and 1627. A public hearing will be offered on this proposal in Austin on February 25th, 2020. Staff respectfully recommends approval to propose the publication of and the hearing on February 25th, 2020, Chapter 114, Control of Air Pollution for Motor Vehicles. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We're available to answer any questions.
Colleagues, any questions?
No questions.
Mr. McWhorter.
OPIC recommends approval for publication of and hearing on the proposed rulemaking to amend Chapter 114 to implement House Bill 1346 and House Bill 1627 as recommended by the Executive Director.
I agree. These are relatively minor amendments to implement legislation, and I will entertain a motion.
I move that we approve the publication of and hearing on the proposed amendments to 30 TAC Chapter 114 as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 52 is consideration of the publication of and hearing on proposed new sections 328.200 through 328.204 of 30 Texas Administrative Code, Chapter 328, Waste Minimization and Recycling. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Kalen Room with the External Relations Division. With me is Colleen Ford with the Environmental Law Division and David Greer with the External Relations Division. The proposed rulemaking would implement portions of Senate Bill 1376 from the 86th Texas Legislature relating to governmental entity recycling and the purchasing of recycled materials. Proposed new Chapter 328, Subchapter K, would document the requirement for governmental entities to establish a program for the separation and collection of recyclable materials generated by the entity. Establish that governmental entities shall give a preference in purchasing for products made of recyclable materials and provide for exemptions from the requirements. A public hearing will be offered on this proposal in Austin on February 27, 2020. Staff respectfully recommends approval to propose a publication of and hearing on Chapter 328, Waste Minimization and Recycling. Staff also respectfully requests approval to make non-substantive revisions to comply with Texas Register requirements. Thank you. We're available to answer any questions.
Thank you. Colleagues, any questions?
None.
No questions.
Mr. McWhorter.
OPIC recommends approval for publication of and hearing on the proposed rulemaking for new sections of Chapter 328 to implement Senate Bill 1376 as presented by the Executive Director.
And I agree, and I will entertain a motion to that effect.
I would move that we approve the publication of and hearing on proposed new sections 328.200 through 328.204 of 30 Texas Administrative Code, Chapter 328, Waste Minimization and Recycling, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item 53 is the consideration of the publication of and hearing on the proposed Federal Clean Air Act, Section 179B demonstration state implementation plan revision for Bexar County 2015 8-hour ozone national ambient air quality standards non-attainment area. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Brian Foster with the Air Quality Division, and with me is Terry Salem with the Environmental Law Division. For your consideration today is the Executive Director's proposed revision to the State Implementation Plan, or SIP, to determine that the Bexar County Marginal Ozone Non-Attainment Area would attain the 2015 8-hour ozone national ambient air quality standard by its attainment date, but for anthropogenic emissions emanating from outside the United States, in accordance with Federal Clean Air Act, Section 179B. Staff respectfully request permission to publish the proposed SIP revision, solicit public comment, and hold public hearings. Thank you. We're available to answer questions.
Thank you. Colleagues, any questions or comments?
No.
Mr. McWhorter.
OPIC recommends approval for publication of and hearing on this proposed SIP revision as presented by the Executive Director.
And I agree.
I agree. I move that we approve the publication of and hearing on the proposed Federal Clean Air Act 179B demonstration state implementation plan revision for the Bexar County 2015 8-hour ozone national ambient air quality standards non-attainment area as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thanks.
Thank you.
That takes us to items 54 through 57, the quadrennial rule reviews for chapters 60, 213, 230, and 307 of Texas Administrative Code, Title 30. The Executive Director's staff is here to present the matter.
Good morning.
Good morning, Chairman, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Patricia Duran with the General Law Division, and with me this morning is Todd Gallagher from the Environmental Law Division. Pending before you items 54 through 57, the adopted rules reviews of 30 TAC chapters 60, 213, 230, and 307. As required by Texas Government Code section 2001.039, Executive Director staff conducted rules reviews of these chapters to determine if the need for the rules within these chapters continued to exist. The proposed notices of the reviews for chapters 60, and 307 published in the August 2nd, 2019 issue of the Texas Register, and the notices of the reviews for 30 TAC chapters 213 and 230 published in the August 16, 2019 issue of the Register, all with a 30-day comment period. No comments were received during the public comment period for these reviews. Based on the reviews of these chapters, the Executive Director has determined that the reasons for the rules continue to exist. In conclusion, we respectfully recommend approval of the adoption of the rules reviews of 30 TAC chapters 60, 213, 230, and 307. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. Project managers and attorneys assigned to these reviews are with us today to answer any questions you may have.
Thank you. I'm sensing no questions or comments from the dais, so we'll move to Mr. McWhirter.
OPIC recommends approval of these reviews and readoption of these chapters as presented by the Executive Director.
Just to be thorough, do we have any questions or comments?
None, thank you.
No, sir.
Okay, then I move that we adopt the rules and, that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code, Chapter 60, 213, 230, and 307 without amendment.
I second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you.
Item number 58 is the public comment session. We don't have anyone currently signed in to speak. So that will take us to the end of the items posted for open session. Items 59 through 62 are for closed session, and the commission will not meet in closed session today.
The time is 10:28, and we are adjourned.